the sort of idea that I think is actually right is not that AI is going to replace lawyers. It's that lawyers who use AI and know how to work effectively with it will replace lawyers who don't.
This is Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Carlin. Please subscribe or follow this feed on your favorite podcast app. That way you'll have access to all our new episodes as soon as they're available. Right now, we're in a period of tremendous legal ferment in this country along a huge number of dimensions, and today we're going to discuss one of them, which relates to technology and changes in technology, and that's the emergence and the use in the legal field of artificial intelligence. AI-assisted tools have been embraced at record speed by legal professionals for things like writing letters, going through documents, and the like, and they offer the hope, I think, of access to justice at lower cost for people who otherwise wouldn't be able to get it, and shortcuts to some of the really tedious stuff that people do, particularly certain kinds of legal research. But, and there's often a but in these things, it turns out that sometimes what you get from artificial intelligence isn't very intelligent. It turns out that lawyers who are using large language model AI programs and the like sometimes produce what are known as legal hallucinations, that is, things that don't exist. And a judge in Wyoming recently threatened to sanction 2 lawyers at a firm who included fictitious case citations in a brief they filed. And they were not the first people to whom this has happened. It's really a problem. And one of the things that's great about Stanford and Stanford Law School is how we relate to the rest of the university. And our 2 guests today straddle the university in a way. The first of these is Dan Ho. Dan is the William Benjamin Scott and Luna M. Scott Professor of Law here at the Law School. He's also a professor of political science. He's a professor of computer science. He's a university by himself. He's senior fellow at the Stanford Institute for Human-Centered Artificial Intelligence. And I think one of the great things about Stanford is that we are really doing human-centered artificial intelligence. And he's also the director of RegLab, the Regulation, Evaluation, and Governance Lab, where his unique combination of experience helps him to help various government agencies and others to figure out how to deal with the emerging problems. He's joined here today by Mirac Suzgun, who's a JD PhD student here at the law school. Mirac's research spans machine learning and natural language processing. He's also co-president of Stanford's Law and Technology Association and the Stanford Law and AI Society. And particularly appropriate given what we're going to be talking about today, before he came to Stanford, he graduated from Harvard College, where he had a joint major in mathematics and computer science, but he had a secondary in folklore and mythology, which turns out to be a lot of what seems to be getting cited. You guys have written an awful lot of papers on this, and I want you to maybe start off by just telling us about the papers you've been writing in this area.
Well, sure. I'm happy to start, and Mirac, you should feel free to chime in. It's such a pleasure to be able to talk with you about this topic. As you said, the case you mentioned was not the first. We had a New York lawyer who appeared in the New York Times as the so-called ChatGPT lawyer, which is not a good moniker if you're a lawyer. And that went all the way up to catch the attention of Chief Justice Roberts in his annual report on the state of the judiciary, where he singled out hallucinations as a real problem. So we had a kind of series of papers on this, and the first one really looked at general purpose AI, where we designed a kind of benchmark suite of around 800,000 queries to just test for the factuality of generated responses. And for then state-of-the-art models, the hallucination rate, that is the propensity to make up facts and legal cases, was between 58 to 88%. 58 to 88% in state-of-the-art models. Then basically a bunch of legal AI providers, Lexis and Thomson Reuters, started marketing a set of materials where they were claiming that they'd used technology to provide 100% hallucination-free legal research engines. And that struck us as odd because it had not been solved yet in AI generally. And so we benchmarked that, and that led to the finding that even for these kinds of tools, the hallucination rate was between 1/5 to 1/3 of generated responses.
So maybe you guys could explain a little bit how these processes actually work, or are supposed to work, I guess I should say.
Of course. So language models are typically trained on massive amounts of textual data. And basically during that process, they are learning some statistical patterns about the ways in which we are using language in our daily life.
So to go back to kind of your previous life, like if you were trained on the Iliad, you would see rosy-fingered, and dawn would be the next word every time.
That's right, indeed. And in fact, that is an important thing to consider because just a moment ago, we talked about the notion of hallucination. And I believe one of the issues that we have seen actually in industry is that different players have different definitions, and they usually favor the definitions that promote their accuracy numbers. So hallucination can occur with respect to the input of the user, or it can happen with respect to the training corpus, or it can happen with respect to the real facts of the world, using a term from Wittgenstein. And this is important to consider because sometimes, for instance, certain statements that we make might be grounded on the training corpus that we have, but it may not align well with the realities of the world. So as an example, consider the Harry Potter character. So if I say that, well, there is someone in this world with a scar on their forehead. So if you're talking about and let's say that that person's name is Harry Potter, who was orphaned at an early age. So presumably, at least based on our knowledge, there is no such person in real world. But if we have the Harry Potter series as our training corpus, then, for instance, this would be a grounded and accurate statement. And I'm mentioning this because basically when we train these large language models, we are using a mixture of fictional and non-fictional training data. And we are using case law and perhaps fictional cases from all sorts of books as well. So it is important that the model also learns about how to discern these fictional cases from non-fictional ones. But at the same time, there might be conflicting opinions as well. So unfortunately, just good old off-the-shelf language models are not good at discerning these subtleties. And furthermore, just because they are looking at statistical patterns, they may not appreciate the subtleties or the up-to-datedness or jurisdictional kind of like distinctions of the cases that you're looking at.
It might help to just give you some concrete examples of the kinds of hallucinations that you start to see. One of my favorite actually comes from a suggestion by you, Pam, which was, why don't you ask these legal AI tools about a completely fictional judge that I've noted in some of my writing, Luther A. Wilgarten, initials Junior, L-A-W, Law, and one of the kind of systems that touts a kind of 100% hallucination-free kind of generation readily responds, sure, I'm happy to give you these cases by the great Luther A. Wilgarten. Here's a case called Luther versus Locke, in which Luther A. Wilgarten wrote. And this goes back to kind of Mirac's point, which is it's really important to be clear about what we mean by what a hallucination is. And when we started to really think about this, what we realized is the definition being employed by some of these companies in their marketing tools was really just talking about whether the underlying case exists. And there is a case called Luther versus Locke. It was not written by the fictional judge Luther A. Wilgarten, and by any ordinary sort of a sense of the notion of hallucination, that has to be a hallucination, but yet we have marketing material out there that says it's 100% hallucination-free simply because that case exists. But Pam, I don't know if you want to share a little bit what the origins of Luther A. Wilgarten might be.
So I think he started in an after-dinner speech by Judge Roger Minor, who was then on the Second Circuit, which is the federal court of appeals that deals with Vermont, New York, and Connecticut. And then a friend of mine who spent a lot of time in Washington and got very tired of people at Washington dinner parties always talking about the judges they clerked for, picked up Luther A. Wilgarten and had an old book bound with a new binding that said, opinions of Luther A. Wilgarten, and put it on his shelf. And he dared me to work Luther A. Wilgarten into an article that I was writing, and I was commenting on an article by another judge who had written about judicial self-restraint. And I dropped a footnote that said, and I feel so inspired by the incredible restraint of Judge Luther A. Wilgart Jr. And so that's how I think he entered the published world of law reviews.
And that, I think, is so telling, right? Because it goes back to what Mirac said, which is these models are not trained really to understand the difference in the authority of the underlying sources. They might treat the Harry Potter novel the same as something else that they're kind of retrieving. And so this law review article that you've put out there containing Luther A. Wilgart could easily be kind of retrieved and result in a kind of generated proposition.
And he must have written something at some point.
Exactly.
Right? Yeah.
And I think that's what's so challenging. One of the other challenges that we kind of documented is that even these legal AI kind of tools that are currently being marketed have very little appreciation of the things that we teach as kind of primitive concepts to first-year law students in terms of understanding the difference between a holding and dicta, understanding the difference between hierarchies of authority. So one of my favorite sort of generated passages was a passage that indicated that the Supreme Court had been overruled on a question of federal law by the Nebraska Supreme Court. And I'm no Supreme Court litigator, but Pam, you as the Supreme Court litigator,
it would have been a surprise to the Supreme Court of the United States to be told that they've been overruled by the Nebraska Supreme Court. Yeah, they would have been surprised about that.
Yeah.
And I wouldn't want to get up there in an oral argument and say, well, yeah, you have some precedent on this, but the Nebraska Supreme Court thinks.
Yes, not a winning strategy. Yeah.
I mean, they don't even have two houses in their legislature. So how did you do your research? What was it that you did in this research to find these results?
I mean, essentially what it is for the earlier one, it was a much easier task to kind of create these 800,000 queries because we could use existing knowledge bases to sort of indicate who wrote the decision in Obergefell, for instance. But for these new generative AI systems that are spitting out mini essay answers, essentially, you have to design a set of questions that are kind of legal research questions, things you might ask during a kind of final exam, for instance. And then there are no kind of easy standards for automated grading. And so we essentially did what law professors do, which is we had a team of us essentially reading through mini essay answers that might have 13 citations and actually read through and determine, number one, is the legal proposition correct? And number two, is it grounded in the underlying proposition?
Because I remember in one of your papers, it seemed like they kept getting Justice Ginsburg mixed up with her daughter, who's a famous copyright professor. And so there was a question about something Justice Ginsburg had done, and they answered with a fake dissent that involved her daughter's copyright work.
Indeed. And that's one of the real challenges here is that this is very early stage technology. And so these kinds of distinctions and entity recognitions, confusing different actors, I think is still very much happening. But I don't know if you want to say
one important thing to mention about these models is that, unfortunately, they are not humble. So the notion of humility is unfortunately very much lacking in these models. And that is partly because of the way in which they are trained. So they are trained to predict the next token, let's say the next word in a sentence or in a paragraph. And because of the strict notion, they unfortunately do not get to say, I do not know the answer to your question. They unfortunately do not abstain in many cases. And that unfortunately introduces lots of problem for us, because one of the things that we tried in our benchmarking effort was to actually construct a set of fictional cases and ask these language models what the holding was or who the judge was in these cases. And we realized that the models, because of the way in which they were trained, they were just trying to kind of give an answer. It is almost similar to kind of like a 5-year-old kid trying to just give you an answer to a question. They do not know the notion of I don't know. And again, going back to Wittgenstein once again, I think it is important to say that whereof one cannot speak, thereof one shall be silent. unfortunately, silence is not an option for these models. So that is kind of like something that we notice. Unfortunately, with our efforts, as well as the efforts of other studies, now these models are learning to actually opt out of giving an answer, but there is still a long way to go. And especially in the legal domain, where precision and accuracy are paramount factors, the model should try to kind of like articulate their uncertainty whenever it is required.
Mm-hmm. It goes back to actually something you started off with, Pam, which is there's this grand idea that AI systems will actually address some pretty severe access to justice problems we have in this country, where in like ordinary civil proceedings, some estimates have it that 3/4 of individuals who would like to be represented are underrepresented. And maybe AI systems can actually level those kinds of barriers. But what's really challenging related to what Mirac just mentioned is this propensity not to kind of second guess what the premise is. And in one of these studies, what we document is that these systems tend to misfire exactly in the places where underrepresented individuals are likely to need them the most. So at the trial court level, or when you have mistaken premises and don't yet know what area of law you actually should be asking about, those are exactly the instances where these models misfire. And that, we think, poses a really significant structural risk. If these models do really well, even if not for Justice Ginsburg on Supreme Court decisions, but not so well for the ordinary eviction or family law case, that kind of promise of AI to actually improve access to justice may really not be the case.
Yeah, I know that here at Stanford, the design lab has been working on trying to come up with ways of putting, for example, kiosks into local courthouses that would ask people questions and at least start to figure out what their problems might be. But what you're saying is there still has to be some judgment in there, and at least at this point, the models have not yet developed the level of judgment.
Yeah.
And unfortunately, also the knowledge, I would say, as well, because in our study, one thing that we realize is that these language models are, perhaps relatively speaking, apt at understanding the judgments of Supreme Court level decisions or appellate court level decisions. But when it comes to trial level decisions, unfortunately, and this is partly because of the inaccessibility of some of these cases as well, these models do not provide the right judgment or the right piece of information about these cases. And many legal providers, legal AI providers, are telling us that AI has the potential to help and support pro se litigants. Those are litigants who are representing themselves before the court. But those people usually do not know not only what to ask, but how to ask their legal questions as well. And when they perhaps ask some ambiguous questions, all of a sudden, even though your perhaps question is related to a Massachusetts torts claim, you might be getting an answer about the torts theory in California. And that is very alarming, because if we give incorrect information to the court, then unfortunately we would not be successful, and then these tools would not be helping the very target group that they intend to help in the first place.
Yeah, I mean, I know from when I practiced and also from what we do in some of our direct services clinics that the ability to ask the right questions and then to figure out from the answer that somebody who's an unsophisticated litigant or an unsophisticated witness, to be able to figure out from that person's answer how to shape that answer so that when it's given in court, it's effective, is a real skill. It's not something that you can pick up immediately.
Yeah, and it goes back to this notion of human-centered AI. That is, that the story that's often told is that these AI systems will wholesale replace humans or lawyers, but really responsible kind of integration of AI really has a notion of kind of human oversight and assisting sort of a counsel in posing the right questions and actually processing the answers in a way. And that obviously is really challenging when you're talking about underrepresented litigants.
Yeah, because they don't have lawyers now.
Yeah,
so
exactly.
So one of the questions I wanted to ask you about is like at what point is AI going to be able to engage in what we sort of think of as judgment as opposed to prediction? I mean, is that years away? Is it hours away?
Well, it's such a profound question. We could have a whole other episode on kind of the notion of judgment here. I think we're going to see really significant improvements. But what our work kind of points to is that the idea that you can have a general purpose kind of chatbot that is the end-to-end solution for all legal reasoning, research, judgment type questions, we're nowhere close to that state of affairs. And I guess when you talk about judgment, right, judgment isn't only the ability to kind of retrieve the right statute or the right case. There is what you've talked about in your work about the sort of Llewellyn sense of situation sense. And so I think what's really interesting about the rise of AI and these decision-making systems is that it actually often also leads us to reflect and interrogate long-standing assumptions about the law itself. So I'll give you one example of that, which is that in procedural due process, which is the sort of constitutional principles around if a benefits claimant has been deprived of a benefit, what process is due. The Supreme Court had this interesting turn really to elevate accuracy, the accuracy of decision-making above all else. And, if we forecast for where the trajectory is going, we might get to a system where for these run-of-the-mill cases, you could actually have an AI system that for the run-of-the-mill Social Security disability case can give you very highly accurate kind of answers that are better, maybe even than a kind of strained human system that right now has, for instance, 1,600 administrative law judges. But there's an independent value to process and judgment itself. And the example I'll give you is from a veterans law judge who regularly would have veterans appear in front of her during a hearing, who would say, I know, Judge, that I'm going to lose, but I just want to be heard. And so what's so instructive about that is that this notion of judgment, right, is the value of it, contrary to kind of where the Supreme Court has gone with the procedural due process kind of line of cases, might not be in accuracy alone. We might actually want to elevate the kind of earlier values of the dignity that comes from a hearing, and maybe AI can assist and free up the time of judges to actually engage litigants in particularly those ways.
Yeah, I mean, Larry Walker, who's a civil procedure scholar from years back, showed that there was a large category of cases in which people felt better if they lost, but they had been heard, than they felt if they won. Yeah. And and the question of at what point people will feel heard if what they did was they typed a bunch of stuff into a box and 33 seconds later something came back to them. Yeah. Is interesting. And it also raises this question because the training sets that they're working on are about the current world, whether that builds in biases that already existed. We had a case in our clinic a couple of years back that involved an algorithm that was used to think about whether or not to release people on bail who had been arrested. And it turned out that it was a proprietary algorithm, so we never were allowed under the hood of it, but it had 20 factors in it. We didn't know how they were weighted and which ones were actually being used. But it turned out that if you wanted to be accurate, you had to take into account the sex of the individual, which judges are not allowed to do. But if you don't take that into account, a lot of women would be held pending trial who should be released because predictively they would not either try to escape or commit another crime while they were on bail. And so this question of if you've got biased training data, you're going to end up with, in some sense, biased accuracy.
Yeah. Mirac, do you want to say a little bit about the historical pattern? Because I think that's actually a really important one, both in terms of the future of where these systems are going, but also a finding that we had.
So one of the ways in which we try to mitigate and detect hallucination problem is through the use of what we call retrieval augmented generation systems, also known as RAG systems. And these principles perhaps have the promise of addressing some of the issues that you mentioned, such as the outdatedness of the documents that we have. Because in the case of RAG, what you do is you first retrieve the most relevant documents based on your query, and then afterwards you start generating your output. So in this way, ideally, you would retrieve the most recent or most relevant documents first, and then afterwards you just kind of like generate. This is kind of like, this should be distinguished from the traditional generation system where we just rely on the internal knowledge of the system. So as you can imagine, the RAG system seems quite intuitive, and perhaps it has the potential to solve a lot of problems. But at the same time, as Professor Ho and Professor Carlin mentioned, in law, you have to pay attention to lots of parameters, such as the jurisdiction or the subject matter or the authority, general authority of the case law as well. And unfortunately, one of the problems that we are still seeing in the RAG system is that they might be just favoring the most recent case law, but that case law may not be that authoritative. Or it might be in the, let's say, Second Circuit, but now we are operating at the Supreme Court level. So it is really important for these models to kind of like pay attention to multi-factors when they are making their evolutions. And furthermore, sometimes it's really important for them to kind of like compare two cases as well. So giving kind of like one concrete example that is quite recent and important, and that is Harvard versus SFA. So in that case, for instance, there was not an explicit overruling of Grutter or Baquet. But if you ask ChatGPT models, even the ones with the retrieval capabilities, actually a certain percentage of the time, these models will tell you that the SSFA decision explicitly overruled Grutter, which is not correct. So there is still kind of like a long way to go, even under the RAG models, because these models do not have a nuanced understanding of case law in our case, or in other domains, it might be medical practices and so on and so forth.
So I have one last question to ask you, Dan, which is something we had talked about the other day, and that is that you had said to me that AI will help to improve the performance of actors at the bottom of the ability scale, but not really improve the performance necessarily of the best judges or the best fact finders.
Yeah, well, this is still very much emerging research, but we've seen a few of these studies, both in law and outside of law, of kind of AI assistance. And what has generally come across in those studies is that AI assistance tends to lift folks who have less experience, who are just getting kind of training on the job, but doesn't tend to boost the performance very much of the sort of high performers. I think it connects a little bit to some of this work on hallucinations too, in the sense that the promise of having this sort of end-to-end chatbot system to give you your little mini essay is that it's supposed to save lawyers time. What we found, it was extraordinarily time-consuming to actually fact-check every single one of these things, because you were getting long answers with 13 citations. You had to go to every one of the underlying citations to figure out, where it was grounded and the like. And that may undercut the very value proposition of AI systems if what that means is associates or partners at a firm have to actually fact-check all of that. And that leads us to the kind of big conclusion, I think, in these papers, which is that a lot of the bar associations have responded to this by trying to just provide general purpose AI training. That is, let's teach people, how machine learning works, what the optimization algorithm is, what a transformer architecture is, and all these kinds of things. And in many ways, what we think that's fine, but it's kind of wrong-headed, because the way that each individual tool is designed can have very different risk profiles, and you have to understand the distinct benefits and risks of those tools. I'll just give you one quick example, which we just stumbled on. For people using Westlaw, you're used to using the Keysight system that throws up a red flag when a case has been overruled. That's the thing you shouldn't, you should be cautious, because there's indication that that's no longer good law. What we found in the system is the way it was designed was that the generated sort of essay answer would generate passages based on an overruled case, but then there seemed to be a second pass in that system that stripped out all inline citations of red flagged cases. That is
Shoot me now.
That is an extremely extraordinarily pernicious thing, because what does that mean for a lawyer? There's no transparency. Like, we just stumbled upon this. There's no documentation of this. And so that means you're potentially going down this rabbit hole of not knowing where a generated passage came from, and you're not given the citation inline in the way that would be ordinary under kind of legal writing, and it could actually generate a whole lot more work than actually save your time. And that's why we think it's so important to do this kind of work here, to have these kinds of interdisciplinary teams to really interrogate and figure out what the responsible uses of these kinds of tools is.
So I guess the one bottom line is that people who are thinking of going to law school today shouldn't decide to go do something else because they're going to be replaced by a machine next week.
I think that is exceedingly unlikely that lawyers will be replaced by next week.
Great. So I want to thank our guests today, my colleague Dan Ho and Mirac Suzgun from the Law School and the Computer Science Department. Okay, so now we have 5 minutes or so for questions. Great. So does anybody have a question? Yeah, there's a question right here.
How is Stanford Law School introducing, or is it playing with AI training generally for students, and how have you found professors adopting or trying to utilize AI in the classroom? Thank you.
We only have 5 minutes for this answer. I'm not sure I'm going to be able to answer all of it. There's a ton going. I mean, one of the really, being here where a lot of this kind of technology is being developed means that there's a lot of different ways in which we've both provided trainings, but also lots of instructors have kind of integrated this into classes in all sorts of different ways. From Lisa Willett, who thinks a lot about this in terms of the IP context, from having starting to utilize these tools to actually come up with different kinds of fact patterns, to having a sort of actual kind of boot camps around law and AI. And we've a kind of dizzying array of different conferences and workshops around these issues. One of our first-year legal research and writing instructors does something I think is really compelling, which is there's a kind of conventional legal research exercise that involves a kind of a panel Ninth Circuit decision that I think misses a particular circuit split. And the students are asked to kind of do the conventional thing that lawyers do, which is do legal research and really understand what is going on and spot the sort of missed circuit split. And then at the very end, she provides the AI-generated answers from all different kind of language models. And that is really eye-opening because you start to realize where these systems misfire. And that's just one of the many ways in which kind of instructors are really starting to bring this into the classroom. But Mirac, do you want to add?
And I can also mention that actually next quarter we are planning to organize a series of workshops on the usage of AI in the legal space together with Stanford AI and Law Association and Stanford Legal and Tech Association. So if you decide to come here, you will be most welcome to join these workshops.
Yeah. And this statement is almost banal at this point, but going back to kind of where Pam left us, right? The sort of idea that I think is actually right is not that AI is going to replace lawyers. It's that lawyers who use AI and know how to work effectively with it will replace lawyers who don't. Technology, there's long roots of technology being used in all sorts of affirmative ways. E-discovery is one of the greatest examples, right? Of, that's the discovery is the process where you could get like 42 bankers' boxes of documents, and the conventional way that people did this is you just threw junior associates and staff attorneys to just do doc review. And basically we figured out through a series of kind of investments involving the National Institute for Standards and Technology of how to actually develop standards for e-discovery so that lawyers know how to actually think about arguing about what the right set of search queries should be to have a kind of responsive form of e-discovery. What should the standard for kind of retrieved documents be and the like. And so those are exactly the kinds of things that I think Stanford is able to really kind of uniquely offer.
Yeah.
Hi, I'm very interested in the intersection of AI and the law. And from my understanding, one of the things I've noted in research is that in reverse engineering some answers, people have been noticing some sort of motivated reasoning in AI models, and sort of almost a bias in wanting to find an answer for users. It seems like people are very good at being able to enter in known entities, or being able to trick AI models, large language models, into identifying known entities. It's kind of like that law example, the LAW person that you were talking about. So do you think there's maybe some sort of fundamental design error when it comes to large language models that's actually causing this motivated reasoning error? I mean, in my experience, I've noticed that it's very good at what you were just talking about, doc review, and actually analyzing a set of user-provided documents and being able to analyze those documents. But when it actually comes to asking questions into the void and sort of just asking it to provide you some sort of question, it seems like that's where we're finding a lot of these hallucinations. Do you think there's maybe some sort of level of corporate acceleration? I hate to call it greed, but maybe kind of, it seems like we're kind of at the point where corporations are kind of pushing this product out. And do we have a responsibility of maybe pulling back and being able to say, hey, maybe that we're not ready to provide this at high stakes industries in business and the law, where there's a lot of high stakes. So should we maybe limit it to doc review and things like that of the like, and leave high stakes industries to human produce work?
It's such a good question, and I think it goes back to what Mirac was saying, which is that these models exhibit what we called model sycophancy. They're in a sense meant to just really sort of respond to the user, whether or not there's a kind of mistaken premise or not. And I think what you're saying is entirely right, which is, I think, a lot of the thinking of responsible AI integration into the legal profession is how to move away from the general purpose chatbot that has way sort of larger kind of risk surface, to what the responsible use cases are in terms of e-discovery, doc review, deposition summarization, and the like, where we just know how to assess the risks and benefits in a much more controlled way. I'll just say one other thing, which is Judge Newsom on the circular is sort of has now written a few kind of concurrences where he sort of says, well, there's this question of kind of statutory or contract interpretation, and I've decided that I'm just now going to turn to Claude and GPT-4 to help me figure out what this, whether an underground trampoline, for instance, counts as quote-unquote landscaping. And one of the things that's so interesting about that is that it often is a mistaken premise that large language models are just like lookups for all of the English language. There's been a big debate, I think, around things like corpus linguistics for originalist constitutional interpretation on the Supreme Court. And one of the things that one of our RegLab members noted to Judge Newsom was that it's not, like, these are not lookup engines. There's actually a whole process where you have armies of individuals doing what's called reinforcement learning with human feedback, where they're essentially kind of tuning this model to try to provide a response of the type that users like. And what that means, for instance, is that one of the ways in which you can still spot sort of AI-generated answers is they tend to overutilize certain words. So the word delve is used much more often by GPT-4. Why is the word delve used much more often? It turns out there is a large Nigerian workforce that is doing that kind of RLHF fine-tuning for these models. And so what Judge Newsom might be getting is not like the dominant kind of use of American English, but Nigerian English, where where the word delve is just used much more than in American English. And without understanding that, you just may have no sense as a litigant or as a judge what you're kind of walking into, and it takes an understanding of how these technologies are designed and what their kind of pitfalls are to really think about using that responsibly.
This is Stanford Legal. If you're enjoying the show, please tell a friend and leave us a rating or review on your favorite podcast app. Your feedback improves the show and helps new listeners to discover us. I'm Pam Carlin. See you next time.